that can only be triggered when there's an official declaration. The body in charge of the elections says that the elections have not been concluded. They are saying that their officers were threatened, were cajoled to do an illegal act, and the law allows them, the CI allows them to ensure that the right things are done, and that is what they've done. There is no official declaration. It is the Electoral Commission that does declaration of results. It is saying that it has not concluded. What it has concluded is the final collation. We declared all our candidates whose matter is in dispute the rightful elected candidates. So that's it. Don't worry.
There's a legal question finally.
Thank you very much. Come back again. That is.
Case against the matter. We are the new, we are the new, Petrote Party. We are the new, we are the new, Petrote Party. We are born to save Ghana. We are the party.
Lord, give me a minute. Give me a minute. I think give me a summary. Just summary. Okay. Good afternoon to our viewers on GBC and GTV News. Currently, we are at the High Court where the application for mandamus was to have been heard this morning by the General Jurisdiction 2 of the Division of the Accra High Court. The case came off, it was heard, but prior to the hearing, the NDC side of the interested parties brought an application, it raised preliminary objections to the mandamus application by the NPP MPs, and arguing that the court did not have jurisdiction to hear the matter because this matter was the mandamus application by the NPP was an election petition in disguise, and that is not the right means to bring such an application to the High Court. They should have brought an election petition to the High Court and not a mandamus. But the NPP, a lawyer for the PCs, argued that an election petition would have been brought to the court if the collation and declaration of the results were officially done. But in the case of the 4 constituencies, they were not. The collation and declaration of the results were not officially done. So the only means by which they could have the court compel come to court to compel the EC to continue with the declaration and the pronunciation of the results was through the mandamus application, which the NDC side disputed disputed by putting up the preliminary objections, raising preliminary objections to the mandamus. This, the court said that it was going to decide on tomorrow, 1st January 2025, if God wills. So basically, that's what happened in court this morning. After court, you heard some of the lawyers say they couldn't make statements on the matter because the ruling of the court is not yet out. You also saw the NPP side of the parties making various arguments and statements about this whole thing. So the genesis of this whole matter is that the NPP, after the December 7 general elections, came to court. That's 6 of its parliamentary PCs came to court with an application for mandamus, asking the court to order the EC to finish the coalition and declaration of results in those 6 constituencies, those affected constituencies. But the NDC, hearing of the mandamus, came to court and served a rejoinder, filed a rejoinder to be joined to the suit. But then on the 20th, when the High Court jurisdiction, General Jurisdiction 13 heard the case, it failed to grant NDC the hearing it sought because it said the timing was not expedient for the court to hear the NDC looking at the importance or the urgency of the application that was heard that day. And so it refused the NDC party MPs their request to be heard on that day. So on the same day, when the court, after the court ruling, NDC went to the Supreme Court with an application for certiorari, asking the Supreme Court to quash the decision of the High Court for the 6 PCs, the order by the High Court for the EC to collate and declare the results of the PCs in those affected constituencies. However, and the Supreme Court, the Supreme Court upheld the request by 4 of the constituencies and asked that the High Court, another judge in the High Court, hear the matter and hear the NDC side, rehear the mandamus by the NPP side, and also hear the application by the NDC to make a final determination of the case. And so this was done, and that is why we are here today, and that is what we heard in the morning when the NDC raised a preliminary objection to the mandamus application by the NPP. Subsequently, where the judge made a ruling that he's going to decide on that matter tomorrow in the morning at 8 a.m. So basically, that is why we are here in court, and that is what we witnessed this morning. So as we see in the background, some members of the NDC and the MPP are here arguing and disagreeing, over whatever we don't know, we can't tell. But initially, the whole place was a quite peaceful mood earlier. They were each trolling or teasing each other, but now it's turning into a bit of a conflict here. But the police is here, so order is in place. And who is on here? What is his name? You know his name?
We are coming to court. We are coming to court tomorrow. No, I'm saying we are coming to court tomorrow. GBC.
Yes. Can we do a quick interview? Can we do a quick? No, but this is for social media. This one is for TV, please. Call Letitia for me. Letitia. Thank you for joining us here on GBC News.
Pleasure.
Can you tell us what happened in court today?
Yes, I think today the High Court was billed to take the mandamus application filed with respect to Tema Central, Ablekuma North, Okankwe Central, and Techiman South. The NDC raised preliminary objection to the application, indicating that it must rather be an election petition, and therefore this court is not the forum by which the case can be heard. I mean, we disagree as New Patriotic Party because we think that for election petition to commence, there must be conclusion to an election, in which case you then go to challenge by petitioning the results. The EC has in itself indicated that in these constituencies, their return officers were not allowed to conclude the process. So we are in the hands of the court. We will come back tomorrow to hear what the court will tell us based on the objection that has been raised by the NDC. We know that their grounds are not solid, but we wait on the court. We know that the New Patriotic Party won the elections in these constituencies, and so we wait.
Interesting enough, you disagreed to the objections raised by Eduji because he said the elections were not concluded. But according to them, the coalition and results were declarations were done in their favor in the 4 constituencies. So how come there's the conflicting argument from each side?
So the EC, by law, appointed returning officers, and it is the responsibility of the returning officer to go through the process, receiving results from all the polling station presiding officers and putting them together. This process did not conclude at that level. That's why the EC on its own, in a press release on 19 December, indicated that in these constituencies, they were going to go back to collate the results, so they will be able to declare the results. So you need to find out from the EC, not from Eduji. They know they've lost it, but they are here making noise. So I will advise you, find out from the EC, find out from their returning officers, find out from the media persons and the security who were there on the said day, 7 December, whether collation was completed.
They also argue that what was done after the High Court's ruling, the previous ruling of the High Court, was recollation and not collation.
I mean, would you want to rely on what they are telling you or what the law is? What the law is collation, not recollation. The New Patriotic Party has never used anywhere recollation. We said that the EC should be made to complete the collation process. So they declare the results and announce a winner. I think this is simple. We've made it clear that the NDC must stop the thuggery and let the rule of law operate. Thank you very much.
So what your final decision? What do you expect, or what outcome do you expect tomorrow from the court?
We cannot predetermine the outcome. We are in the hands of the court. My pleasure.
So we just heard one of the MP executives telling us that they are in the hands of the court, and whatever the court decides tomorrow is what they are going to go with. We go on to other officials and get some reactions from them.
It is well. We raised an objection, preliminary objection, to their case that they filed. We thought that it's a wrong method they've used. They are using ambush tactics, backdoor window, to force the arms of the state institution, EC, to do their bidding. That is the trick they are trying to do. The people have voted, the returning officers have done their work. The law, the EC, has given those powers per the CI 1272 returning officers to declare, collate and declare parliamentary results. So that power rests with the returning officers. Okay, it doesn't rest with the commissioners, Madam Jean Mensah and the other commissioners. They don't have those powers. It is the returning officers. So when they finish their work and declare somebody winner and you are not satisfied, pay PNDC law 284, okay, subsection 16 and 20, you come to High Court and file a petition against those declarations with enough evidence so that the court can set it aside the declarations or ask for this.
But your opponent said that there was no official collation and declaration of the results, so to say. But you are saying there were collation and declaration of the results, and it went in your favor. Is that what you are trying to say?
Your media houses carry the declarations. Your media houses, they carry those declarations live. It was done live. It wasn't done under somebody's bedroom. It was done at the collation centers. Live cameras, policemen standing there, and they held the hands of the various candidates having been properly elected and declared. You get my question? So that is what they have done. They have done their work. So that mandamus they are asking for, that work was done. Not that it was done, and they were declared officially at the collation centers. So if you are not satisfied, you know the path to go. You don't come by mandamus and saying that they should go back and do something they have done already. They have done it.
In Summer Central, the argument of the NDC applicants is that the returning officer who declared Ms. Bright the winner was not the official returning officer who should have done that, and so it makes it null and void.
It is only the High Court that can make such announcements or pronouncement that it was null and void. Not Madam Jean Mensah and her commission. They don't have that power. They should show which part of the law that allows them to sit in their office and say it was done in error, and therefore they are not upholding it. Tell me which part of the law. CI 127, the 63 pages, which part of the page is saying that Madam Jean Mensah has that power? We are not in a jungle. Let's do things legally. That's why the law court is here. The path for them to do that here, High Court, come with a petition. Let the judge set it aside, and then we now get whether it's true or not. It doesn't lie in their mouth. What they are doing is illegal. It's a lawless institution that we are now having, and we must correct them. The EC first become a very lawless institution.
They also claim that what was done, per the ruling of the court from the previous courts, which compelled the EC to go on with the declaration, was not a real declaration, but was the conclusion of the collation and declaration of the elections. Do you agree with them, or what is your stand on that?
There is nothing like that. We don't have anything like that in our books. The CI 127 is very clear. Just go and read Regulation 43. You will see the procedure used in collating and declaring results. The presiding officers haven't satisfied themselves with the procedure, went ahead and declared the results. If you are not satisfied with that, you don't sit in your office and say they didn't do it, they didn't do it. Let the judge see it, not you, the commissioners. They don't have that power. That has been our position all along.
Do you expect tomorrow's ruling to go in your favor?
Of course, we have just given the evidence. We have given enough evidence. The mandamus was meant to do what? To ask them to do an action that they thought they have not done. But those actions were carried out by the returning officers, not Madam Jean Mensah. They have done their work. They have finished. And they have sent their results to them. If you are not satisfied, let us battle each other through a petition. We'll battle each other. But you don't come through this back door. This is a backdoor method. Ambush tactics won't allow it. It's a very, very unknown procedure to our laws. We won't accept it. That is why we are here. You see, we are not lawless. NDC is a very law-abiding institution. That's why we are here. If we were to these people, they would have used state guns to go and ransack the place and declare themselves winners. 2020 is evidence. You saw what they have. They stole 5 seats through guns, kill people. Have we done that? And say we should go to court. They don't want court.
Alaji Computer, thank you so much for your time on GBC. So there you had Alaji Computer, one of the NDC legal directors for the elections, and saying that their party is a lawful party and will do this through the legal means and will not use violence in getting justice or getting their case heard, basically. So that's it. So from the courts will decide on the preliminary objection raised by the NDC tomorrow, 1st January 2025, as to whether it has the jurisdiction to sit on that application or not, and whether the NPP MPs brought a mandamus, an election petition in a disguised form, or whether it's mandamus is also allowed by the courts for this kind of hearings. So here we have it. This is the court, this is the High Court, and this is what transpired today. And so we'll be here live tomorrow to give you updates on what happens in court. Thank you.
Afi siapa afi nko nensa mensa ye ho bio ye de nyame ase